Hello, everyone. This is Gaston from the Markman Advisors here with this week's Markman Minute, in which we take a closer look at one of the patent litigation situations from the prior week that is of interest to investors. And this week we wanted to follow up on a important case that we highlighted actually back in April, and that's a case between Rovi, which is a company that has a large portfolio of patents in the area of TV guide listings and related functionality, and Netflix. Now, Rovi and Netflix have been in litigation since 2011, and as we spoke about in April, Netflix had raised a challenge under a recent Supreme Court case called the Alice decision, whereby they asserted that 5 Rovi patents that they were in litigation with were invalid, but not only invalid, that they never should have been issued in the first place because they were directed to what we call ineligible subject matter. In short, Rovi has patents, according to Netflix, that are not patentable in the first place. And the case that, as we highlighted back in April, the case has been pending for a while. This motion was actually on the judge's docket for a few months, and earlier this week, the judge actually issued her decision. And much to the chagrin of Rovi investors, the decision was very negative. She actually found that all of the patents in the case were Alice, or, to put a different spin on it, were directed to ineligible subject matter, and therefore were not patents that should have issued in the first place, and therefore Netflix wins. Now, obviously, judgment has been entered at this point in Netflix's favor, and as it stands today, Rovi gets nothing from the case. But we fully expect that Rovi will appeal, and in fact, the company was very proactive. Once the decision came out, it actually came out after market hours, and by the time everybody woke up in the morning on the East Coast, the company had already released a PR announcing that, saying what they could say, which is that, hey, we have a lot of other patents. We want to get money out of Netflix and everybody else that, licenses our patents, and we're going to appeal this negative decision. And that's really the best they could do. But for now, Rovi stock took a big hit based on the decision because I think people rightly feel that this case is a bellwether, and that, if Rovi isn't able to assert its patents in litigation against those people that it wants to take licenses from and are unwilling to take licenses from Rovi, then perhaps Rovi's existing licensees, when it comes time to renew their contracts and licenses with Rovi, may take a more hostile approach and not be as forthcoming with the kind of money that Rovi needs to justify its share price and valuation going forward. So from the perspective of this case being having an impact on Rovi, I think that impact has already been felt. But at the same time, I think the real impact might take a little while to develop. What investors are going to be looking at is not only whether or not Rovi is successful on appeal of this decision, but whether or not Rovi is able to continue to announce the big re-signing of big licensees, which is the real core of their business. What's clear, though, between this decision and the decision last year in the Amazon case is that 2 of Rovi's biggest targets have declined the invitation to license, have gone to litigation against Rovi, and have shown some success. So that in and of itself, I think, speaks to some of the challenges that Rovi faces. And in a more kind of macro point, I think it's also important to realize that this may be the prime example of a case where the Supreme Court decision in Alice has actually had a measurable economic effect on a company. No one knows at this point, because no one's looked at every one of Rovi's patents, how many of their patents are susceptible to this kind of to the type of Alice challenge that Netflix was successful in bringing to the fore in this case. And whether or not Rovi has to do a comprehensive reevaluation of its portfolio is something that remains to be seen. But if people thought that the Alice decision really was limited in terms of impact to patent lawyers or companies that are in the software space, I think we now have a very market-focused example of what can happen to a company when what we thought was a valuable patent portfolio is tested in litigation, and the judge uses an Alice decision to decide that it's actually worth absolutely nothing. That's it for this week's Markman Minute. My name is Gaston from Markman Advisors. You could check out all our content at mimesislaw.com under the intellectual property tab. We've gone to a daily system in terms of releasing notes of interest with respect to daily patent litigation events, and you could always catch our prior videos and content at mimesislaw.com along with a host of other great content. Thank you very much. See you next time.